Our guests in this segment are in studio and via telephone. In studio, Stephen Skinner from the Skinner Accident and Injury Attorneys. Stephen, good morning. Welcome back to the studio.
Good morning. It's good to actually be in studio. I think it's, you and I have been talking since I think 2008.
Probably, yeah.
Ish, something like that.
Yeah, I started doing this show in 2010, so probably about that time, yeah.
And I had always come into the studio, and then, of course, COVID sent us our different ways, and I think this is the first time I've been back in studio.
Yeah, because we've done a lot of shows with you about various ideas, and they've always been over the phone.
Yep.
Well, welcome back.
Glad to be here.
Great to have you. And via telephone, Greg Thomas with us from West Virginia Citizens Against Lawsuit Abuse. Greg, good morning to you, sir.
Good morning, gentlemen. How are y'all doing today?
Very good. Your title lists you as the General Consultant for West Virginia Citizens Against Lawsuit Abuse now for 20 years. Greg, how did you get started with West Virginia CALA?
I'd run a state legislature. I ran my first state Senate race for a lady named Lisa Smith against Oshel Crego, who was then the state Senate Finance Chairman all the way back in 2002. And I guess at that time they were kind of, the organization had been around for a while, but had not been overly political up to that point, and they were looking to have somebody sort of, do the media stuff like this, but also kind of get a little bit more involved in politics, which we did, and we've had a lot of success with that, and so we're a organization that has over 20,000 members statewide, and been around for about 25, 30 years, and, just trusted. It's the state's only legal watchdog organization, and we're, focused on civil justice reform issues.
I want to throw out the words judicial hellhole, right? Because when I started doing this show 15 years ago, those two words were thrown around together a lot to describe the West Virginia legal situation. And I know one of the things that your group wanted to tackle, Greg, was getting West Virginia off of that list. Do you think you have successfully achieved that? And if so, what were the steps you took to do that?
We did achieve that. There was, sort of the first thing we did, and some of your longtime listeners will remember the McGraw brothers. One of them was on the state Supreme Court. He had been the Senate president. One of them was the Attorney General. He had been on the state Supreme Court. And those guys were very liberal on these issues. We had a couple of elections and remove those guys. Morrissey actually beat Darrell McGraw in the Attorney General's race. So we got involved in the Attorney General races, state Supreme Court races, and then around 2012, 2014, started getting involved in state legislative races. When the Republicans took over, you had the change of leadership in Charleston. We passed dozens of legal reform bills, eventually created the Intermediate Appellate Court, and all of that sort of culminated in West Virginia getting off of the judicial hellhole list. So, we've made a significant amount of reforms. And then we still have stuff to do. I mean, there's always stuff to do, but, a lot of the heavy lifting has been done. And, we're very appreciative of all the support we've gotten over the years to help enact those reforms.
And you were a lobbyist for the American Tort Reform Association. Stephen, you were in the House of Delegates. I know when a lot of the discussions about tort reform in West Virginia began to take shape. I'm not sure if any of that got passed while you were still in the House of Delegates, but as a practicing attorney in West Virginia, did you feel there was a need for tort reform in West Virginia?
Did I feel there was a need for tort reform? No.
Why not?
I still don't. I mean, we've had we need to kind of wind this back and explain to folks what we're talking about here, both in the federal Constitution and in the state Constitution. We have a right. This is a guaranteed right to a jury trial. That means that if you have a civil dispute with somebody else, you should be able to take it to a jury of your peers and have them decide it. So if we start with that, anytime you are trying to take away any piece of that access to the court system, to a jury, is chipping away at those rights. So, I think I have a lot of faith in the folks in West Virginia and their ability to sniff out something that's not right, and also to make sure that justice gets served in the courtroom. And we do that every single day. So it's also, we have had a lot of the so-called tort reform for many, many years. It goes back long before I started serving in the legislature. We had medical malpractice began to change, and it gets changed almost every year in terms of little amendments here and there get introduced. So there have long been changes to the law, but I'll tell you, I think that the folks that I continue to be associated with in the state, the people who stand up for injured people and consumers' rights, we are always willing to sit down and negotiate and try to listen to what the actual issue is. And if a business is having, if the business community is having an issue, we'll try to solve those problems. And we continue to do that through today, even on some of the issues that are popping up, like medical monitoring. Long history of discussing that, and we can get into that. Mm-hmm. But we've negotiated around that, and we get agreed bills. And these are things that aren't terribly controversial. We're willing to listen and make changes. But I do want to, if we can just step back for a second. Sure. There's some idea that this organization, CALA, has 20,000 members in the state. I think that's probably a fiction, and so that's just their email list. I think that if we're probably all counted as members here because we're all on the list. One of the things that they have never revealed along the way is who funds them, like who pays the bills at CALA. I welcome Mr. Thomas today to reveal who actually funds it or where the money comes from. Actually, the history of the organization goes back through Big Tobacco. When you look at the tobacco litigation that helped to bring accountability for Big Tobacco, we can trace back through lobbying efforts in Washington to create these so-called grassroots organizations to go out and pretend to be grassroots. So they're really AstroTurf organizations. They're fake. And they claim to have some legitimacy throughout the state, but they don't really. And so what we're talking about here are big industries, a lot of polluters, tobacco, who fund these efforts to try to protect themselves from accountability. So I think
well, let's give Greg a chance to address that. Greg, you feel free to bite off and chew any of that and spit it back out as you wish, sir.
Yeah, look, obviously Citizens Against Lawsuits is connected to the American Tort Reform Association, so we obviously we do receive some funding from them.
Greg, your cell's starting to fade a little bit. Not sure if you moved to a different position or not, but
I'll stand closer to the window.
That's good where you are now, man.
All right. Sorry about that.
Sure.
So look, do we have 20,000 active members? Obviously not. This is a culmination of just over the years. People did opt into this. This isn't just a matter of like, hey, we don't just go and grab 20,000 random names and say this is this. It's a culmination of a long time of being involved in different efforts and, different associations getting their people involved in the group. And, so it's, it is it's, I wish I had 20,000 emails. I don't have 20,000 emails, but, we have 20,000 addresses.
Yeah. You're starting to break up again, Greg. Yeah. Do you want to call us back and reestablish the signal?
I can. Is it better now?
Yeah. Right now you're nice and clear.
Just don't move your head at all. Don't breathe. Don't move anything.
I'm not at my house, so it is somewhere where I'm new.
Yeah. You're good there, though.
Okay. So anyway, I think that, obviously, look, the American Tort Reform Association is made up of people that employ hundreds of thousands of American workers, thousands of West Virginians, healthcare providers. It's anybody that is a business, a hospital, doctors. All of that is who we make up. I would say, look, we're not against jury trials. Mr. Skinner's right. We have done a lot of tort reform. I don't know. We don't know any, I think you'd be hard pressed to find somebody that says, hey, I'm not allowed to file a lawsuit because they've passed this tort reform. I mean, that's really not the case. We have come in, we have negotiated with the other side on a lot of these things to get them passed. Charlie Trump, now Justice Charlie Trump, but then, Senate Judiciary Chair Charlie Trump from y'all's area was real active in this for years, and he did a good job of, getting everybody to the table to make a lot of these changes. And I'll say, Mr. Skinner, I've never met Mr. Skinner. I've been involved in a couple elections. We helped back then. We helped Patricia Rucker, when she ran against you for delegate, and you beat her by a couple hundred votes, and then she ran for Senate and won. And with respect to that, I'll just say that I'm sorry. If I knew Patricia Rucker was going to vote exactly like you were going to vote on legal reform, like she does now, I probably wouldn't have helped her all those years back then.
She appeared on your Dirty Dozen list of elected officials that you called out for the way they voted on things. Let me backtrack to tort reform for a second here, and I'll ask you both this quick question here. In regards to tort reform, Stephen, does tort reform necessarily mean fewer rights for the aggrieved?
Almost always. I mean,
in what manner? How does it manifest itself?
Well, can I just walk you through what happens every day across the state, where I get lawyers receive calls for, let's say, a potential medical malpractice case, and they describe something that is clearly a case of malpractice, and we have to decide: can we file a suit on their behalf? In order to file a medical malpractice case, we actually have to today hire an expert and pay that person thousands of dollars just to give an opinion and tell us whether they think the case is legitimate or not. This is a piece of paper that we then have to engage in. Before we file a lawsuit, we would have to share that opinion with the other side, where they have the opportunity to force a mediation prior to filing suit. So that process right there probably costs $5,000 to $10,000 off the top. Then, if you're going to begin the case, you're probably looking at costs that are, minimum of $20,000, $30,000 more in order to get to trial. So when you're looking at going to trial in a medical malpractice case, you're looking at sort of the minimum of $30,000 to $50,000. So let's say the injury only resulted in $5,000 worth of extra medical bills for someone. It's still significant, and they had to miss work. Let's say they missed a week of work because they were misdiagnosed. They had to go to a different doctor who then discovered it. They come to me and say, hey, this is medical malpractice. Do we have a case? You can't even begin to address whether it's a case or not, because that minimum amount of money that it costs to bring the case is so significant. Compare this with a car wreck, where we can say, okay, yes, you were in a car wreck. Yes, I can see your medical bills, and it's going to cost us a filing fee of $400 to file your lawsuit. We don't have to hire an expert. It's something that is optional. So what has happened because of tort reform in West Virginia, particularly in terms of medical malpractice, is that the costs to bring a lawsuit are so high that you basically have to have an injury that is hundreds and hundreds and hundreds of thousands of dollars in order to justify bringing that case. So somebody who has a significant injury that maybe only has impacted their life $100,000, they get told no. So probably about 95% of cases get turned down in the medical malpractice context, because the lawyers who bring these cases, we can't, the numbers don't justify it. So they've made it so expensive to bring the case, maintain the case. We don't bring the case unless it is very, very significant.
Greg, go right ahead.
Look, expert testimony is not a novel concept, right? I mean, this isn't something that only happens in West Virginia. I mean, juries aren't equipped to make medical determinations. This aids in that, right? I mean, it's not unique. Most of the legal reform we've done just tries to bring West Virginia in line with other states. We're not trying to do things here in West Virginia that they're not doing elsewhere. The reason that West Virginia was always number one on the judicial hellhole list is because we were a state doing it differently than everybody else. I mean, if the defendant's found liable, right, they ask for attorney's fees, okay, which are granted all the time. They can go out and get their $5,000 in damages or $50,000 or $100,000, but the lawyers are also getting their, plenty of attorney's fees, right? I mean, these are in many instances, these are paid by the defendant. The other thing too is they know the majority of these things are settled out of the courtroom anyway, right? I mean, like almost all the legal reform we've done is probably focused on less than 5% of actual lawsuits, right? I mean, we're just going in and trying to get the worst examples, the big-time litigation, the stuff that scares away employers, the stuff that shuts down doctors' offices. That's the stuff that we're trying to get rid of. And so, this isn't about, we're trying to make it to where you can't file a lawsuit. We're trying to make it where you can't file frivolous lawsuits or make it to where a lawsuit doesn't result in $50,000 or, $50 million worth of damages.
By the way, we're going to get into SB 473, the medical monitoring bill, coming up after the break at 9:31. Go ahead, Jonathan.
So why then has it been made so difficult for somebody to file a smaller claim? Like, why is it easier to protect your car than it is to protect your body? That doesn't make sense. If you're saying you guys are worried about these gigantic verdicts, why has the tort reform, or why have you guys pushed for the tort reform where it is costing, they've got to have $5,000, $10,000, $20,000 worth of stuff before they can file something, where if somebody has a $20,000 problem, it just goes away because, they got to deal with it because it's not worth filing.
Well, look, they settle all lawsuits. I mean, you can't – any lawsuit that's $35,000 or less or $50,000 and less, they all get settled by the insurance company anyway. Everybody knows that. I mean, almost all the tort reform we do anymore literally has a floor of either $35,000 or $50,000. So to say that the little lawsuits don't get filed, they don't get filed because they do get filed. They just get settled. They just don't actually go to court. He's not having to hire expert testimony for a $20,000 case because they're just giving him the $20,000 to go away.
But a lot of times insurance companies aren't as liable to settle something if there's not the threat of a suit, and if they know it's got to be a large amount for it to be worth it.
You're dead on about that. There's no doubt about that. You know what I mean? Like there's so again, we're not saying that you can't file the suits. We're just saying, right, like most of the you'd be hard pressed to find a bill that we focused on that goes after $25,000 lawsuits. We just don't do it. It's just not something that we do. It's not, that's not what we're here for, to be quite honest with you. And the reason that we have medical liability reform, I mean, if you go all the way back to, Mr. Skinner did bring it up. I mean, this happened just as I was actually went to college in Virginia and moved back. And just as I moved back and was getting involved in politics is when they had the medical liability reforms. And if you remember, that's because doctors literally could not get medical malpractice insurance in West Virginia. The insurance companies had just left the state. And then Governor Bob Wise is the one that came in with a with a total Democrat legislature and passed medical liability reforms, which is the things, we're sitting here complaining about right now. But I mean, this is something that, this is a problem we fixed 20 years ago.
And we needed to, because they have to have med mal. If they don't, we have no doctors.
Yeah, that's what I'm saying. And if we were out here attacking $50,000, $25,000 lawsuits, I think a lot of the stuff that Mr. Skinner said would be true. It's just we're not actually doing that. I mean, we passed a seatbelt admissibility law just a year or two ago, and we either put a $35,000 minimum or a $50,000 minimum, and once we started doing that, we offer that up on almost every bill we try to pass.
Stephen?
Well, the question was about tort reform and what is the cost of tort reform? And they've shifted the cost and raised the barrier in many, many cases so that these smaller claims, in particular medical malpractice, cannot be brought. And they're not settled. Unfortunately, the health insurance for the people who are the victims of medical malpractice, that has to absorb all of the costs, and then the people have to absorb it themselves. So those smaller claims, they're not settled. They're not, and anybody will tell you that. So specifically when we're talking about medical malpractice, and if we solve the problem of the so-called problem of medical malpractice in West Virginia in 2005, then why are there amendments every couple years to medical malpractice to make it harder and harder and harder? There was this line of all the doctors are fleeing the state because they can't get insured. Turns out that when you trace all of the barriers to medical malpractice access to the courts in all the states, it's the same story. I have no idea where all the doctors went to when they were fleeing, because all the states had exactly the same problem. And today, health insurance companies, are they profitable? Are the pharmacy benefits managers, are they profitable? They're making hundreds and hundreds of billions of dollars a year, and who's paying for that? Right? It's we are, the people are. And are making it more difficult to have access to the courts goes into the profit.
And Greg, hang out there. We're going to do a 4-minute break here. We'll be right back. Can you stay with us?
All right. Yes. Appreciate it, guys.
Very good. Absolutely. And Stephen, you're staying for the second half hour as well.
Sure.
And as we head into the break, we'll in studio attorney at law Stephen Skinner from the Skinner Accident and Injury Attorneys.
Glad to be here.
Via telephone from West Virginia Citizens Against Lawsuit Abuse, Greg Thomas. Greg, welcome back.
Thanks, guys.
Hey, let's talk about SB 473, the medical monitoring bill. And this really is what kind of kicked this off, Greg, because you put out a press release naming a dozen people you called the Dirty Dozen on that list: Senator Tom Willis, Senator Patricia Rucker. I understand that Senator Jason Barrett, the finance chair, also voted in a manner that you would not have approved of. He was not on your list. Was there any reason why Barrett wasn't on your list too?
No, these were just in judiciary. He didn't vote on these.
I see.
I think Barrett's been with us. Barrett's been with us on legal reform, I'm pretty sure, before. So I think he's a supporter. And then, like I said, Rucker used to be a supporter, and then she started, last election, she took $20,000 from liberal Democrat personal injury lawyers in Charleston. And now she's changed her vote, and she is now not only against legal reform, but sort of organizing the Republicans to be against legal reform. I mean, this medical monitoring is something that we've passed 2 or 3 times through the state Senate. And there were 3 or 4 people that have voted on medical monitoring before that voted against it this time.
Greg, give me your issues. Give me your issues with the medical monitoring.
Yeah,
and why you don't like it.
West Virginia is one of only a handful of states in the country that allows these types of lawsuits. These are essentially we call them no proof, no problem lawsuits. You don't actually have to have an injury to file a suit. It's just the threat of an injury. This originated back in the late 90s. There was I don't know if you guys remember the diet drug Fen-Phen, but there were a lot of lawsuits around this diet drug, and there was a Charleston attorney named Scott Siegel that had these lawsuits. His wife, at the time, she was on the state Supreme Court, and they created. So this isn't something that the legislature passed. This is essentially court-created policy that allowed for these types of lawsuits. There was a 1999, there was a front-page Wall Street Journal article talking about how bad West Virginia's court system was because of this. It's really one of the big reasons that we were on the judicial hellhole list. We've passed a ton of legal reform, and this is probably the biggest thing still out there. that we, and so look, we don't want to do away with the lawsuits in general, but we want to do away with this being the cause of action. So, look, it's something we've passed before. This particular legislature has not passed a lot of bills that would be kind of pro-jobs. We think this is one of the first ones they even voted on, and Rucker and others voted against it.
Stephen, what about SB 473 and medical monitoring, as that bill was written, would cause you to disagree with Mr. Thomas?
Well, let me point out a couple of things. First, I think there are 15 states that clearly recognize medical monitoring. Other states there may be medical monitoring that isn't. It's a little bit unclear. Let me give a really great example of medical monitoring here in the Eastern Panhandle. A lot of folks know that there was a leak into the public water system of the city of Martinsburg that was filled with toxic chemicals, the AFFF, PFAS, forever chemicals. So these leaks were basically being delivered, the chemicals were being delivered into the water supply for the city of Martinsburg. It turns out that these chemicals cause cancer, kidney cancer, testicular cancer, other things like that. And so what medical monitoring would do would, if you could bring a lawsuit against the cause of the leak or the manufacturer of the chemicals who had been withholding the public health information about the contaminants, then the people who had been drinking the toxic water for 16 years could then have their doctor's bills paid for when they go to get their blood tested to see how high their PFAS, forever chemicals levels are, and also to monitor the particular risks of those chemicals. So, this causes preeclampsia, it potentially causes infertility, all these things. So who should pay for those costs, right? Should the individual and their employer's health care plan, or the state of West Virginia with Medicare and Medicaid, should they have to pay for those costs for the contamination in the water? To just monitor to make sure that you're not one of those people. And people, by the way, have gotten those cancers who were drinking that water for a really long time in Martinsburg. And I think it's fair to say that the costs of that monitoring should be paid for by the people responsible for those chemicals. And that's what this is, right? Relatively straightforward, that the people who are causing the problem should pay for the problem. Now, this bill...
For how many years? What would be... How many years is a reasonable amount of time?
I think that's something that you would, in a legal action, you would have doctors debate what's reasonable. When does the risk go down to such a level that you no longer need to monitor for it? Just like any other medical issue, when you have a cancer and you can slow down in the monitoring of something specific about it. You just go in once a year and get a CAT scan, something like that. So I think that's something for debate. Now, the group that represents the lawyers who represent consumers in West Virginia, regular everyday people, have always been willing to negotiate on this issue. And they were certainly this year willing to negotiate again on this issue. But my understanding is that Mr. Thomas was not willing to sit down and negotiate a bill on this issue. And my question would be, why not? And in the past, there was a negotiated bill that got all the way through, and my understanding is that Mr. Thomas helped kill that bill in the end, even though it had been negotiated in the process to come up with some solutions that would address some of the problems that they raised. So, some of this, I wonder whether it's performative, right? If we don't have the boogeyman to fight, who do we fight? So we've been willing always to sit down, hear the concerns, negotiate something, and if it's something that we can agree on, then let's do it. And this year in particular, there's been nothing. no willingness to negotiate. So I don't know why we can't do that and come up with reasonable solutions. Most of us in West Virginia can sit around a table and say, all right, I can't do that. Let's do this. Let's come up with, let's say you can do it no longer than 15 years, for example, on the amount of years. We'll come up with these guidelines, but we don't have that this year. And I think it's something I think it would serve us all to be able to have these kind of discussions and come up with solutions.
Greg?
Yeah, there's two different things here. One is, look, I'm a layperson. I'm not a lawyer like a couple of y'all. But it's my understanding, though, that the statute of limitations it'd be told until the discovery of an actual injury related to the water contamination comes to exist, right? So, I mean, if somebody there did get cancer, right, so somebody is actually injured, then you can come back and do the medical monitoring, right? Like if somebody is, they can. But the purpose of this is to say, hey, we're going to allow you to collect money because someday maybe somebody gets sick, right? If somebody gets sick, you can go all the way back to that time and say, all right, here's all the stuff that I've done, here's the things, all that gets paid for, right? It's just if you don't actually have an injury, what are we giving you the money for? And the reality is in West Virginia, we don't have a medical trust fund, and this is sort of the second part that Mr. Skinner is referring to. We don't have a medical monitoring trust fund. So the way it is, Justice Spike Maynard, when this decision came out, he dissented. He called it the Ford F-150 decision, right? And that was because you went out and you got the money, right? So this, and we're not talking about, these aren't $100,000 cases. These are $100 million cases, right? Where the personal injury lawyer is walking away with $35 million. Scott Siegel, who I mentioned earlier, that had the FenFen litigation, he built a $17 million house in Charleston overlooking the Capitol, right? This isn't small-time stuff. These things aren't filed every day. And so what happened then, or what can happen in West Virginia, is you get all that money up front, you give it to the person that could or may not be sick. They don't have to spend the money on medical monitoring. They just went out and bought an F-150, right? And so, so what he's referring to on the negotiation is the trial lawyers have said, hey, we're willing to create this medical monitoring trust fund, where there's two parts to the bill. That's the second, much less important part. The important part is to say medical monitoring is not a cause of action, right? And so there are 15 states that recognize medical monitoring, but there's only 4 states that represent it as a cause of action, and that's what we're trying to do. So, look, if I didn't have anybody get to me this year to negotiate, we have had years past where, they wanted to do just create the medical monitoring trust fund, which at that point we weren't willing to do because we really wanted to get rid of the cause of action. So, look, this isn't fake. It's not, this isn't some sort of dance. This is a real issue that major employers look at, and as they, site selection's a huge thing. And this is something that manufacturers are going to look at and say, oh gosh, medical monitoring is a cause of action here. If something goes wrong, and even if no one actually gets hurt or gets sick, I still have to pay millions and millions of dollars. No thanks. I don't want to come there.
Matt Miller.
All right, I'm still trying to wrap my head around and make sure I'm understanding things. So, Stephen, I want to start with you. In a case like the PFAS situation and the water in Martinsburg, if there is some sort of a suit filed, does that tend to be individual or more class action covering multiple people who may have taken, that water into their system, and now there is that concern? And under medical monitoring, is the only money at the beginning helping to, pay the cost of tests that need to be done until something maybe does come? And so let's say I lived in Martinsburg for those years. The tests get paid for, and then eventually one of those tests does say, I have cancer. Now that changes everything, and I file a totally different suit, correct?
Generally, I think that's a good way to characterize it. I do want to say it is not, you don't get a Ford F-150. You don't, most of these cases would be in a class action to give access to a fund that people could apply to get their test paid for. You don't just get a chunk of change that you could spend on a Ford F-150. That's just not true. And that was inflammatory language, I think, designed to do what it did.
Do I have to prove that I've gone to get the test, right?
These things get set up in different ways.
Okay.
I think one of the things that you might want to all go see is the movie Dark Waters that has a sort of a movie. Yeah, it has, and that's we kind of live in a little dark waters situation in Martinsburg and dealing with the PFAS that was in the water here. But you might come up with a program. You might partner with a local health agency to say, we want to be able to test folks, and this is money that's available, and people will go in and get their tests, and it gets paid for. It's not a bonus for people to do whatever they want with the money. I do think that we need to understand that this is not something that prevented Procter & Gamble from locating into West Virginia. The things that companies look for when they locate to a state like West Virginia are infrastructure, education, a trained workforce who actually goes to work. Right now, I just took a look this past week. Steve Roberts of the West Virginia Chamber of Commerce wrote an editorial about the issues facing West Virginia in terms of businesses. And what did he identify as the things that are holding us back today? Well, he doesn't mention lawyers or tort reform. He points out that childcare is one of the most important things, and that the state should get involved in subsidizing childcare, and high taxes for business, including an inventory tax. I think it's insane that everybody on July 1 gets taxed on the inventory that businesses own in the state. So they're literally people who, companies that move their inventory out of state for a little bit. Well, apparently some folks have private jets that they move to a different airport on July 1. They never want to be in the state of West Virginia. Those are some business executives, but so July 1, those are tort reform leaders, and so why am I paying an inventory tax on my computers on July 1? It's anti-consumption, right?
Let's get back to tort reform now, Stephen. Right?
So,
not tax reform.
But let me tell you, those are the things that the West Virginia Chamber of Commerce says is holding us back right now.
Not attorney
Not
situation.
medical monitoring.
All right, back to you, Greg.
Okay.
Go ahead.
Yeah. Look, I do agree with Mr. Skinner on his tax stuff there. So I knew there would be something we'd agree on today, and being against, I guess there's two things: being against Rucker and being against the inventory tax. But look, and he's not wrong. Like there's the economic development's a three-legged stool. It always has been the basic stuff, right? And it's taxation, litigation, and regulation. Over the last 10 years, West Virginia has made a lot of improvements on all three of those things, right? We had the largest tax cut in state history. It was a personal income tax cut, not the business tax cut that we were just talking about. So that still needs to be done. We've passed a lot of legal reform. There's been a lot of regulatory stuff. Patrick Morsi, the Governor Morsi's got a couple bills this time that deals with some regulatory things that I think that are going to be really helpful. So look, this isn't some sort of cure-all, right? I mean, what we're talking about is West Virginia was out of step with the rest of the country. We were the worst legal system in the country. We've done a lot to fix that. One of the things that is still left is the medical monitoring decision, the cause of action, where we're one of only 4 states that has it. The other bill that came up the other day, if you don't mind me transitioning into, was the one that dealt with hiring outside counsels of cities and counties, right? So back in 2017, when Patrick Morsi was then Attorney General, we passed a law that said, hey, when you go out to hire outside counsel and file lawsuits on behalf of the state, There's a process. There's a sort of a bidding process. There's a lot of transparency that we got instilled in that, and there was actually a fee structure of how much lawyers could be paid. And that very much came into play during this big opioid settlement, right? The state had this big $1 billion opioid settlement, and personal injury lawyers were paid $151 million. $151 million. Some of them enough to get a private jet, which I'm sure they move on July 1st. And so what this did was,
Touché.
I think they have to move it June 30th to be in compliance, but I'm not a tax guy.
Yeah. So there were lawyers that were paid for by the state that were essentially paid like a 7.5% commission, right? But these are big numbers. So it's not like you can't find somebody to do it. These guys still made $30 or $40 million. Then all the different cities and counties went out and hired their trial lawyer buddies to get in on this to represent them. The cities and counties are not held to the same regulatory framework. So these guys, no bid process, hired their buddies, didn't pay him the 7.5% that Morrissey paid his. These guys were being paid 35, 40% in some cases. And so what this bill was aimed to do was just to make the lawyers that are hired by cities and counties held to the same regulatory framework that the Attorney General's office is held to. And so we felt this was important. Patrick Morrissey even had a court filing in that opioid settlement saying, hey, here's how I paid my lawyers. This is how the cities and counties should have had to pay their lawyers. And if they would have paid their lawyers according to this framework, opioid victims would have received $100 million more dollars.
And that was
that
was SB 543, and that did not pass, correct?
Correct. The same group of people that Rucker and them sort of organized, voted against it. They essentially made the argument that, we shouldn't be telling the cities and counties what to do, right? Which is funny because just yesterday they voted on a bill, and I'm sure you followed this. Some of you guys followed this. They voted on a law that said that cities and counties couldn't have non-discrimination regulations, right? So when these guys want cities and counties to have control, they do it, and when they don't want them to have control, they go in and make the state get control.
Greg, thank you very much.
The intellectual dishonesty among this group is unparalleled.
I've got 45 seconds left. Stephen, do you want the final word?
I think that Berkeley, Morgan, Jefferson counties, their county commissions are more than capable of putting their thinking caps on and making independent decisions about who they hire and how they hire. We have some of the best county commissions in this state, if I do say so myself as someone that they hired. This is like, we don't trust our county commissions to make decisions, even though we have some of the most talented, smart, educated people in the state.
Stephen Skinner, thank you very much.
Thank you.
Mr. Thomas, how can we find out more about West Virginia Citizens Against Lawsuit Abuse?
WVCALA.org, and guys, I appreciate the opportunity.
Thank you, Greg.
Thanks.
Greg Thomas from WVCALA and Stephen Skinner from the Skinner Accident and Injury Attorney. SkinnerWins.com is how you find out more about those folks. Final minute next.